Now we move on to the next set of questions and passage. Since the dawn of time, humans have engaged in some form of arbitration to resolve disputes, giving this private adjudicatory process a prehistoric origin. Even with the rise of formal state courts, arbitration continued to thrive because it offered a less formal and costly alternative to traditional court proceedings. At its foundation, arbitration is a private dispute resolution process where two parties agree to have a neutral party, third party, an arbitrational tribunal, making a final and binding decision. The basic principle of this process include the equal treatment of all parties and adherence to the principle of due process. Over time, however, the integrity of arbitration was compromised by an imbalance of power between the parties. More powerful entities often included one-sided clauses in arbitration agreements that gave them the sole right to appoint an arbitrator. In India, this issue was partially addressed by the 2015 amendment to the Arbitration and Conciliation Act 1996, which incorporated concrete standards for arbitrator impartiality by adding the 5th and 7th schedules. However, many powerful parties continued to exploit this loophole, leading to awards from biased arbitrators that caused grave injustice. This controversy was definitely resolved by the Supreme Court in the landmark Core Judgment 2024 case. A constitutional bench ruled that an arbitration clause allowing one party to unilaterally appoint an arbitrator is unconscionable and violates Article 14 of the Constitution, which talks about equality, which guarantees equality before the law. The court held that such a clause is inherently exclusionary and that any resulting award is de jure void. This judgment, which invalidated thousands of arbitral awards, was a crucial step in ensuring that the resolution of private disputes adheres to minimum statutory standards of equality and fairness. To further promote efficiency and integrity in arbitration, technological advancements have been embraced. The Indian Institute of Arbitration and Mediation (IIAM), for example, launched projects like Gateway to Justice (G2J) project, which uses an online dispute resolution (ODR) platform called DigiResolve. This platform, which is powered by artificial intelligence, is designed to make the arbitration process faster, more cost-effective, and more accessible. It streamlines the entire process from filing requests to issuing awards, ensuring that all proceedings are guided by legal requirements. It also includes an additional supervisory layer, the scrutiny board, to ensure that the arbitral awards align with all mandatory legal requirements. This move toward technological integration and institutional support is a critical step in modernizing India's arbitration landscape. So the paragraph mainly talks about the process of arbitration. What is arbitration, and why is there why certain amendments were made to the original Act of Arbitration and Conciliation Act 1996, which is prevalent in India, and even after the changes made to the Arbitration and Conciliation Act, there has been some violations, and a judgment came into existence for overcoming this violation. And the aftermath of that is discussed in the passage, and also certain digital initiatives by the Indian Institute of Arbitration and Mediation is discussed in the last part of the passage. So arbitration you should know, and after while the primary reading of the passage itself, we get the notion that arbitration means two parties are having dispute. So we have to resolve this particular dispute, right? So we are introducing a third person having no bias or no leniencies towards either of these parties. So that particular third party, neutral party, would be the arbitrator, and the arbitrator's decision would be final and binding. So these two parties agree to have a neutral third party, and then the third party makes a final and binding decision. So this process of arbitration was taken by lots of people, even in the prehistoric times, because litigation is always time consuming. It is a costly process, while arbitration, it is a much more summary procedure, and also it's cost effective. So people always chooses arbitration over traditional court proceedings. We know how many cases are lagging in the Indian courts. So people, especially when companies or when two entities or two people, when they enter into some kind of contract or agreement, what people would do is that they would introduce an arbitration clause in that particular agreement. So if I am owning a company and I am there to avail services of storage facilities. So I went down to a storage facility company, and if I'm selling laptops or computers itself, for example, I'm selling laptops or computers. So I need a storage facility. So I'm entering into a contract with that storage facility saying that I have this many storage of laptops. I have 50 laptops in my hand right now, and I'm giving it to you for safely keeping those laptops. So they will be having certain provisions, terms and conditions and all. So we will be signing an agreement that I will give them this much laptops only for storage purposes, and they will maintain it in a reasonable man's ability, and they'll give it back whenever I ask for them, and they'll be having certain terms and conditions. I also will be having certain terms and conditions. We both have our rights, duties, everything will be discussed and written. That is what a contract is. You might have heard the classes of contract, so you will be familiar with the ideas and concepts of contract. Okay, so I am writing this contract, and there is a possibility that there might happen some kind of disputes. We might be having some difference of opinions. So we anticipate that we will be having in some future, if at all we are having any difference of opinion, we will go to an arbitrator. So one clause will be included in the contract, in that agreement itself, that if at all some dispute arises, we will be having an arbitration at this place, means India, or if we are specifically saying Kerala, Tamil Nadu, we'll be having arbitration at this place, and we'll appoint an arbitrator. I'll appoint an arbitrator, and the storage facility will appoint an arbitrator, and both of them will togetherly decide on another arbitrator. So there will be a panel of 3 arbitrators who will decide upon our dispute. So there will be no partiality as to who selects the arbitrator, etc. So that is the example of an arbitration clause. So people anticipate it nowadays, and they include as a part of their arbitration. Okay, while looking into the passage, it says that in the second paragraph, over time, the integrity of arbitration was compromised by an imbalance of power between the parties. More powerful entities, what they did was that they included one-sided clauses in the arbitration agreements that gave them the sole right to appoint an arbitrator. There is another, now I said that while writing a contract, they add an arbitration clause. And there is another thing also, the parties, they willingly sign an arbitration agreement, another agreement which is solely made for this purpose. So the thing is that the passage says that there is a problem that prevailed in India, even now it prevails, because more powerful entities, they add unilateral clauses in the arbitration agreements so that the arbitrator would be biased towards them. So even if the arbitrator, it acts as a neutral third party, actually it will be appointed by one party alone, and the decisions of the arbitrator will be biased towards that powerful party. For overcoming this bias or this exploitation of the provision, 2015 amendment was done to the Arbitration and Conciliation Act 1996, which is the parent act that governs all the provisions of arbitration and conciliation in India. However, still after this amendment also, this particular exploitation continued, and thereafter in 2024, last year, the judgment in the core case came. So this judgment ruled that an arbitration clause allowing one party to unilaterally appoint an arbitrator is unconscionable and violates Article 14. Article 14 speaks about equality before the law. Okay. So after that decision, many of the judgments, the thing is that how this works is that we go to an arbitrator instead of going to a traditional court arrangement for a civil dispute or a commercial dispute. We go to the arbitrator for deciding the dispute, and after the judgment award, the arbitral award, we obtain the arbitral award, we go to a traditional court itself for its execution. Okay, so after getting this judgment, we go to the execution part to a traditional court. But the thing is that many arbitration agreements, the arbitrations were done in the way that only one party appoints an arbitrator. So he appoints an arbitrator who would give them a favorable decision. Okay, so many sole arbitration cases were there. After this particular judgment, every such of that awards went futile, or they were discarded because they cannot be executed in the traditional court. That's how the process. Arbitrational award is there. That award should be executed by the court itself. So several number of such awards were disregarded. So the passage talks about the application or the aftermath of this 2024 court judgment, and it speaks about the DG Resolve platform launched by the IIA Institute. Okay, now we move on to the questions. Arbitration is best described as dash. Okay, a public adjudicatory process conducted by the state, a private dispute resolution process where the parties accept a third neutral party's decision as final, an informal mediation without binding consequences, a substitute for judicial review by higher courts. So when we look into the passage, it is clearly written as arbitration is a private dispute resolution process where two parties agree to have a neutral third party, an arbitral tribunal, to make a final and binding decision. So when coming back to the question, arbitration is best described as, is it a public adjudicatory process? No, it's a private dispute resolution process where parties accept a neutral third party's decision as final and binding. So option A would be ruled out because it is a public adjudicatory process, which is not true with respect to arbitration. An informal mediation without binding consequences. First of all, it is not mediation and it has binding resolutions. It's the decision of the arbitral tribunal would be final and binding upon the parties. That means that the parties have to abide by that. They cannot dispute against that particular decision, or they cannot just run away from that decision. They are binding upon the parties. A substitute for judicial review by higher courts. What is the concept of judicial review? Judicial review is not just resolving disputes, right? Judicial review acts as a check and balance on the government, especially because the courts ensure that the state governments and the union governments and the legislative or executive organs of the government, they act in consonance with the constitutional provisions or their particular legislative limit. The judiciary checks these recurringly and ensure that we are having a good system of governance. We are having a constitutional system of governance. So judicial review acts as a check and balance upon the actions of the government. It is not the best description for arbitration because it is nothing in relation with arbitration procedure. So the correct answer would be option B, a private dispute resolution process where parties accept a neutral third party decision as final. So arbitration is different from mediation. Arbitration decisions are final and binding upon the parties. They have to obey it. It is mandatory and it is a private dispute resolution process. Okay. Now moving on to the second question. Which of the following constitutional principles did the court judgment primarily uphold by invalidating arbitration clauses that allowed a single party to appoint an arbitrator? So they have given options as certain fundamental rights in the options. So which of the following constitutional principles did the court judgment primarily uphold by invalidating arbitration clauses that allowed a single party to appoint an arbitrator? So when we look at that action of a single party, we are having a dispute between two parties, right? But a single party, a powerful party only is appointing an arbitrator. So what is the problem in that? The other party was denied the opportunity to contribute into this arbitrator thing, and one other party, they solely held the right of appointing an arbitrator. So there is a violation of some right, right? They are not in an equal footing. Somehow this party who appointed an arbitrator is having a much more higher leverage because they can appoint an arbitrator who would decide the case in favor of this party. So there is an unequal footing. So there is violation of equality, right? So we look into the options. The right to freedom of speech. That is not what is denied in this particular situation. The freedom of speech is a right. It is a fundamental right. So the dispute here or the problem here is that the party could not speak is not the problem here. The right to life and personal liberty is option B. It is mentioned in Article 21. Option A is Article 19. The right to life and personal liberty of the party is denied here. No, right? Option C, right to equality and procedural fairness, Article 14. And option D, the right to constitutional remedies. The constitutional remedies is also fundamental right enshrined in Article 32, which says that if any of our fundamental rights are violated, we can we can approach the Supreme Court under Article 32 so that this rights are enforced for me. If my rights are violated, if my life and personal liberty under Article 21 is infringed by the state under Article 12, which is defined in Article 12, the right of life and personal liberty is enshrined in Article 21. If any of my fundamental right mentioned in Part 3 is violated by the state, I can go to the Supreme Court under the Article 32, the right to constitutional remedy, so that these rights are enforced for me. If my right to education was violated, I'll be given the opportunity of education. If my life and personal liberty are at violation by the state, then the court says to the state entity that this right should not be violated. So my rights can be enforced under the Article 32 constitutional remedies. But does the appointment of arbitrator by a single party envisages this particular option, right to constitutional remedies? No, right? There is an unequal footing between the parties, and that would directly lead us to the option C, right to equality and procedural fairness. Let's see whether we can point out this answer in the passage. See, the passage says that in the third paragraph, a constitutional bench ruled that an arbitration clause allowing one party to unilaterally appoint an arbitrator is unconscionable and violates Article 14 of the Constitution. So, even it says Article 14 of the Constitution, which guarantees equality before the law. So, we need to know either it is Article 14 or the equality provision, and it clearly says that allowing one party to unilaterally appoint an arbitrator is violative of Article 14. So, the correct answer would be, as we can directly see from the passage, option C, the right to equality and procedural fairness mentioned in Article 14. And we move on to the question number 3 of this passage. The principle of odi alteram partem, central to arbitration as well as judicial proceedings, ensures what? Option A, a fair trial is available only if the arbitrator is a retired judge. It is not at all mentioned in the passage. Option B, the parties must be given an opportunity to be heard, which is a principle of natural justice. We should know the meaning of the Latin maxim odi alteram partem in order to answer this. The option C, the arbitrator can act as both a party and a judge in the dispute, which seems a little bit irregular, right? Because two parties are in a dispute, and we from the passage we came to know that a third neutral party is introduced in this particular system, who can act as a non-biased entity so that the disputes are resolved amicably and neutrally. So, can the arbitrator act as a party and a judge? Can, for example, we can take the previous example of I am having 50 laptops and I'm reaching out a storage company for storing the same. So, if we are having a dispute, and if I feels that I deposited 50 laptops there and only 49 laptops were returned to me, so I decide that as per our agreement, we are having an arbitration clause, so we'll get into an arbitration, and I feel myself that I'll be doing a cost efficient method, that I'll be acting solely as the judge of this case. So can I act as such? Because that is not the primary concept of arbitration procedure, right? Arbitration procedure, two parties will be having a dispute, and a third neutral party will be entering into the dispute for an amicable settlement or a binding decision between the parties. Okay. So the arbitrator cannot act as both the party and the judge in the dispute, which will be against the basic principles of arbitration. Option D, arbitration awards are always subject to appeal in higher courts. The thing is that while looking into the proceedings of arbitration, why people choose arbitration over the traditional court proceedings, we discussed it already. But the thing is that arbitration proceedings, they have only limited grounds for appeal, so that every arbitration proceedings after their end, people don't get the opportunity of appeal suddenly. So it is always a binding and final decision in most cases. It only has limited grounds of appeal. So arbitration awards are always subject to appeal in higher courts would be a wrong way to describe this odi alteram partem decision, because it is not true at all. A fair trial is available only if the arbitrator is a retired judge. Option A is also not true. So we are left with option B and C. The arbitrator can act as both the party and the judge in the dispute is also wrong. So option B. And the thing is that if we are given any legal maxims, try to figure out the meaning of words odi alteram partem. So ODO, it is related to something about hearing or sound. So you can relate. If you are not at all familiar with the legal maxim, just try to find out by the certain words what are words could be included in that particular maxim. But audio alternate partum is a very fundamental principle which you have to know, which means that option B is the correct answer. Let me say, parties must be given an opportunity to be heard. Audi alteram partum. The thing is that the other party also is to be heard before giving a judgment. So the thing is that audi alteram partum. You should also know that legal maxims, they are mostly in Latin term because of the origin of legal principles in the Roman culture, and also Latin as such is a dead language. It is not evolving anymore. So that if legal maxims are made in that particular dead language, there will be no ambiguity or confusion to the words as such, because if the words are changing or new slang meanings or any different meanings are attributed to a particular word, that will be difficult in case of bringing those concepts to the legal field also, because the courts use or the legislations use these particular legal maxims as the foundations, so that they can clearly look into something. Odi alteram partem means the parties must be given an opportunity to be heard. So that principle is very clear. So while the courts interpret using these principles, they are clear that this particular legal maxim is clear. So whatever we have to decide should be in adherence to this particular concept. If even in this particular concept there are ambiguities, that will be difficult for even the judiciary to take this maxim into consideration and interpret upon those principles, right? So legal maxims are made in Latin language, which is a dead language, which gives it more authenticity because it leads to less ambiguity and confusion. Okay, audio alternum partem means the parties must be given an opportunity to be heard. Each of the parties in arbitration, both the parties are to be heard before reaching a final decision. So this audio alternum partem principle is very core and central to arbitration as well as traditional judicial proceedings. Okay. Well, moving on to the next question. Arbitration differs from judicial adjudication because arbitral awards are dash, always subject to revision by appellate courts, which should not be true, because why? Arbitral proceedings, as said in the passage, it is final and binding. See, it is a final and binding decision, which means that there is less room for further appeal or further revision by the appellate courts. There are grounds, but there are only limited grounds. So from the passage, we can say that if it can be revised again and again, this arbitration proceeding would be a futile proceeding. Like, we can surely go for the traditional court proceedings, right? We should not choose arbitration over traditional court proceedings. Why we choose this arbitration proceedings over traditional court proceedings is that they are final and binding, and it is cost effective, and there is less time span also. So it is option A would be a wrong answer. Consider private opinions without legal force. Arbitration differs from judicial adjudication because considered private opinions without legal force is not a correct answer, because we have, as the passage says, Arbitration and Conciliation Act 1996, which embodies all set of rules that is binding upon the arbitration proceedings. Only according to these provisions mentioned in the Arbitration and Conciliation Act, we can do arbitration proceedings in India. Option C, final and binding with very limited grounds for challenge under section 24. Option D, enforceable only if both parties agree after the award. So for option D, we should check the correctness of that particular option, right? The passage itself, again moving on to the passage, it says that arbitrational decisions are final and binding. That means that, as I said earlier, the parties cannot disagree that I feel that this particular decision of the arbitral tribunal is not good or was not correct. The party to the arbitrator cannot make such an agreement, or there is no room for such a disagreement after the award. Somehow, if he likes it or not, the arbitrational award is binding upon him. He should obey the same. So that option D also is incorrect. And from the passage directly, we can see that arbitration differs from judicial adjudication because its decisions are final and binding, and there are very limited grounds for challenge under Section 35. So option C would be the right answer. So try to rule out the left of the answer if you're confused with some answers. Try to rule out other options. Okay. And the fifth question, under Arbitration and Conciliation Act 1996, arbitral awards are dash. Enforceable as a decree of the court, only advisory opinions, subject to revision by high courts, automatically void after 3 months. So we can look into the paragraphs for the answer. It says that the arbitral decisions are final and binding, which rules out option B. Only advisory opinions is not the right answer, because if it only advises, the parties are at will to either agree it or disagree it, or obey it or disobey it, but it is mandatory, it is final and binding, so option B would be wrong. Subject to revision by high courts. Just you look at the fourth question where it says that final and binding with very limited grounds for challenge under section 34 adjudication. That is, arbitration means it has only very limited grounds for challenge. As option C is correct, we know there is only very limited room for challenging. So when we look at the option C of fifth question, subject to revision by high courts would not be the correct answer. B is also ruled out. Automatically void after 3 months is also not correct. It is at par with the traditional court proceedings is what being said in the paragraph. So option D also would be not correct, because traditional court proceedings, once a dispute is decided, it is final and binding, because it means that it cannot be changed afterwards. So automatically void after 3 months would be a wrong perspective. So it is option A, enforceable as a decree of the court. As in the paragraph is seen, arbitration proceedings is equal to the traditional court proceedings. So arbitration is equal to traditional court proceedings means that it is enforceable as the decree of the traditional court proceedings. So option A would be the right answer. We have one more question in this paragraph. So it gives us a situation, a hypothetical situation, and we have to, by applying the principle given in this particular passage, we have to answer this question. A bank and a client have an arbitration agreement. A dispute arises and the bank, a more powerful party, unilaterally appoints an arbitrator who happens to be its former employee. So there we can see that a bank and a client are having an arbitration agreement. Then a dispute arises and the bank, who is a more powerful party, they appoints an arbitrator unilaterally, and who is that arbitrator? He happens to be a former employee of the bank. So we can see that there is a little bias towards the bank right now. This situation undermines the principle of neutrality and independence in arbitral proceedings. We know that that is correct. The failure to prevent such appointments reflects inadequate enforcement of which statutory safeguard? So the question is that the failure to prevent such appointments reflects inadequate enforcement of which statutory safeguard? So there is unilateral appointment of an arbitrator by a party. So the failure to prevent such an appointment is mentioned in which safeguard? So we can look back into the passage. It says here that in India, this issue of unilaterally appointing an arbitrator was partially addressed by 2015 amendment to the Arbitration and Conciliation Act, which incorporated concrete standards for arbitrator impartiality by adding the 5th and 7th schedules. So it says that the 2015 amendment made to the Conciliation and Arbitration Act 1996, that particular amendment incorporated concrete standards for arbitrator impartiality by adding the 5th and 7th schedules. So it says that an arbitrator should be impartial. So in order for the arbitrator to be impartial, the 5th and 7th schedules were added in the Arbitration and Conciliation Act 1996. So we get back to the question. It has given us a hypothetical situation and asks us that the failure to prevent such an unilateral appointment reflects inadequate enforcement of which statutory safeguard. So we read just now from the paragraph, that passage given that in 2015 an amendment was made to the Arbitration and Conciliation Act in order to prevent the impartiality of the arbitrator. So we can check whether that particular answer is there or not. First one is Supreme Court's ruling in the core judgment. A judgment is there in 2024 which says that unilateral appointments, such arbitral awards are void, was the judgment of the Supreme Court in the core judgment. But it is not a statutory safeguard, right? It is a judgment made by the judicial organ, judiciary. So statutory safeguard will be made by the legislative body. The arbitration clause in the contract. Who makes the arbitration clause in the contract? That is a matter between the two parties, between the agreement. That is also not a statutory safeguard. That is not a violation of, as per the question, that is not the violation of a statutory safeguard. Then option C, 2015 Amendment to the Arbitration and Conciliation Act 1996, Section 12 on disclosure and ineligibility of arbitrators. As we read back into the passage, we saw that the 2015 Amendment to the 1996 Act brought in the concept of impartiality of arbitrators. So that would be the correct answer. We can also look at option D, the principle of locus standi. Locus standi means who is eligible to institute a case, who is having the legal standing for instituting a case is the concept of locus standi. That is also not related to this question of reflecting the inadequate enforcement of which statutory safeguard. So right option would be option C. It says that the 2015 amendment to the Arbitration and Conciliation Act says about ineligibility or impartiality of the arbitrators. So we have looked at these many passages and discussed the questions. We will move on to the next set of questions in the next class. Okay, thank you.